stand by while NCLA cuts through the noise to signal abuse of administrative power. This is Administrative Static with Mark Chenoweth and John Vecchione.
Welcome back to Administrative Static. I'm here with Mark, and we are going to discuss, there's various ways you affect the law. And some of those ways are suing people, and some of those ways are writing articles to influence other folks. But one of the things you have in regulatory law is that when an agency wants to make regulations, there's the notice and comment process, which is the agency puts out proposed regulation, and then everyone in the country really is invited to comment upon it. And there's sometimes some cynicism, do they listen? But I have seen rules change and be changed by the type of comments that get put in. And also even whether they have the power. And usually agencies always say, we do have the power, but nonetheless, they have to respond, because if they don't respond to comments, one of the Administrative Procedure Act allows courts to send it back to the agency or overturn regulations if they refuse to respond to comments that are made. So New Civil Liberties Alliance makes comments on various proposed regulations. And we did that last week for the Federal Trade Commission. The Federal Trade Commission has asserted an ability to make regulations about non-compete clauses that are in many contracts across the country. In fact, they claim in the regulation that it's 20% of the people employed in this country are under a non-compete. And now a non-compete is in the regulation, but just also colloquially, is an agreement you enter into where you say you won't go work for anyone else in the same industry for a period of time. And usually it has also a geographic restriction, commonly 20 miles for like if. And this was originally came out for things like sales lists. If you were a salesman and you knew all the customers and all the sales lists, you couldn't take that with you as sort of an intellectual property, but you could just have it in your head. So they didn't want you to go in all those people. So that's how the 20 miles emerged. And so the FTC has said that it is an unfair condition of employment, and that they're going to outlaw all the non-competes in the country in all 50 states. And I have to give a sort of admission against interest. I spent a lot of my life litigating against non-competes. I've never liked them. I certainly have never liked them for regular employees. I represented a guy once who was a LASIK technician, and he learned his abilities in the Army. No one trained him, because that's another reason for non-competes. They give you training. They don't want you to take your training to someone else. So I litigated that case, and I've litigated a number of these, even for highly compensated people, but they're always a hammer to hold over the employee. But I don't much like him either, John. I don't know if I've mentioned this to you, but my dad was the victim of a non-compete clause, and he was a family physician, but he was working for a company that saw people in nursing homes, and he had signed this non-compete, I think, not thinking much of it, and his had a 100-mile radius for 2 years. And so he basically had to move out of town for 2 years to work, because he couldn't work anywhere that he could commute to. All right. So neither of us are fans of non-competes, but again, with administrative law, you always have to make sure they stay in their lane and within their power. So we filed a non-compete here because the FTC doesn't have this power. And I'm just going to run through some of the reasons where they don't. First, it's unclear whether the FTC can make regulations this broad under unfairness, right? They have certain antitrust, but just in terms of their rulemaking power, generally. So they said the FTC Act 6 allows them to make regulations in support of Section 5, which is the unfairness power. And that's somewhat up in the air. And I thought it was fascinating. Mark and I attended a Federalist Society conference on administrative law that was here in DC in the Mayflower on Tuesday. And there were two former FTC commissioners, one a chair. It was, I think it was John Leibowitz and Noah Phillips.
Yep, that's right.
And it was moderated by Judge Rao. It was fascinating, but
from the DC Circuit.
So the way that this ability to put out regulations was confirmed was in a case that only went to the DC Circuit, and the Supreme Court has never talked about this power. And the case was National Petrol Refiners Association versus FTC, and the FTC had made a regulation about putting the octane levels of gas on your on the pump.
This is that 87 and 91, 93 you see
exactly.
when you go to the gas tank.
And the DC Circuit said, yeah, they can do that. They have regulatory power, but it's never gone all the way up to the Supreme Court. And there've been other doctrines and cases since then that have put a lot of pressure on this. And it was interesting because the Federal Society usually has people on opposite sides of issues, and they did. To some extent, former Commissioner Leibowitz and former Commissioner Phillips have somewhat different views.
Well, they were appointed by different parties.
Yeah, in different parties, but they're both like solid knowledge of how regulatory law works. And both of them said, this case is under a lot of pressure. And so this DC Circuit case might not be approved if it comes up again. So part of our comment in this,
especially if it were something that weren't as sort of easy to comply with as slapping a label on a gas
correct
tank, right?
Correct. And so I think that's just the first thing. Are they allowed to do that? Then the other part of the comment was that, look, these are common in all 50 states, and all 50 states have laws against them. And we point out that many states don't allow them. California hates them. They're in most places, they're all strictly interpreted. That means who's ever benefiting from the non-compete, the non-compete is interpreted against you. So the courts have put in types of things to make these less onerous. And then the legislatures have come in certain places like Hawaii doesn't allow it for medical people, right? And so the states have been looking at this and doing things. Congress hasn't done anything about it, but the states have. And
have some states banned them entirely?
Yes. So California bans them entirely. There are other states that do so as well. And a lot of them ban them by industry. Some ban them by amount of money you make. So there's lots of different things. But what the FTC did here is they used their power to preempt. Federal law can preempt state law. And I have a problem with agencies preempting state law, but they are allowed to do it. And they actually did it in the regulation. They say we are preempting all state law that differs from this regulation.
Well, I'll tell you this. If you want to tee up a case to challenge the question of whether a regulatory agency can preempt state law, this would do it. I don't like the FTC's chances of prevailing on that
because
theory.
Congress can do it. So Congress could, I presume, in most of the cases go this way, they delegated their preemption power, some portion of it. But here, the preemption...
Explicitly.
Yes, explicitly. But here, the preemption power is going to run into West Virginia v. EPA. And our real point of the comment, I think, is that this is a major questions doctrine. And the FTC was clear on the breadth of this.
Yeah.
They not only said, we are covering every non-compete in this country, we are also going to say the breadth of the problem, because we believe that it covers over 30 million people. We believe it is 1/5 of the American workforce under this. Well, that sounds like a major question, right? And the major question doctrine hasn't been fully explicated yet, but I'm pretty sure it's going to fall in there.
I think so too, partly because regulation of contracts is a highly traditional state law area of regulation. That's not something where you see a lot of other federal regulation to come in. And I mean, you see it in a few things on race discrimination and so forth. But
or the Labor Department can say, here's what we do in union contracts, that sort of thing.
Minimum wage law.
Right.
There's different things like that. But so much of it is still left to the enforcement of contracts is really a state law issue typically.
That's exactly it. And I think one prong of the major questions doctrine, if you look at the previous cases, I don't know if they said it in West Virginia EPA, but is whether or not it has federalism problems. That's one of the things you can look at. So I think this is all the things. This is like they're really
this checks all the boxes.
They're checking all the boxes, and they're doing it on purpose, I think. And so the other thing is the FTC doesn't regulate everything.
It's like a donkey in a china shop.
Yeah. So, for instance, banking isn't regulated by the FTC. So I don't believe this rule would cover things like banking, the various things the FTC isn't allowed to have them and carved out. So there'd be non-competes in banking and nowhere else. I mean,
that's a good point.
They are saying that this would be uniformity, and they want every worker's rights to be the same across the country, but it won't be because the FTC doesn't have jurisdiction over some areas of the economy.
And I don't think the courts are going to defer to the FTC's gloss on its own power here either.
No. And I'm just going to, I will say there is a question, and here I'm going to throw it out there, and this is in public, but here's the question. They did say that there was a certain article they wanted people to comment on, and we didn't comment on it, but it was basically saying that non-competes for people who are not compensated highly are really the problem. And I believe that maybe they know as well as I do about the major question doctrine, the problem with Section 6 and all the rest of it. But maybe when the comments come in, they will just pick a level of income and put the rule under that. And this is maybe scaring the chickens, and then they'll pull back and make it look fine. Still may not have the power, still have court cases, but maybe they think they'd be in a better posture. So let's see if they do that. The FTC has not been that participation. We will see.
Welcome back to Administrative Static. We have a treat for you. We have brought back for your listening pleasure our colleague, Clegg Ivey, Director of Engagement here at the New Civil Liberties Alliance. Clegg has been running the King George III Prize, calling out the worst government abusers of civil liberties for the last several weeks. And Clegg, we are down to the Flagrant Four. So drum roll, please.
Well, Mark, it's great to be here. Thanks so much for having me. The Flagrant Four is here. There were some amazing last-minute face-offs, but in the Flagrant Four, we got two folks we knew were going to be here. We saw it at CPAC in the straw poll that we took. That is Gavin Newsom, the California governor, and Merrick Garland, the United States Attorney General. No surprises there. They steamrolled over their competition. But there are...
Which that's Gavin Newsom defeated Michael Reagan, the administrator of the EPA, and Merrick Garland defeated Rob Flaherty, which is maybe a little bit of a surprise because he's gotten a lot of notoriety for all of his nefarious social media censorship.
That's right. Yeah, the White House digital communications director who was behind a lot of the censorship on social media that we saw last year. I think in general, Merrick Garland was just too well known. And also, Merrick Garland was also associated with and part of that censorship industrial complex. So Flaherty didn't really have anything different to offer. And of course, Garland is also someone that we sued over the bump stock.
Except for really snarky emails. I think Rob Flaherty had some really snarky emails. That,
I have to tell you, I'm going to be sad not to be able to use the Ted Lasso memes that came around. There's a lot of Rob Flaherty kind of looks a little bit like Sudeikis, who plays Ted Lasso. So
I hope Flaherty doesn't going around wearing Kansas shirts like Ted Lasso does and embarrass us like the Westboro Baptist folks always wearing their Kansas shirts around.
Well, there are pros and cons here, but yeah, that's right. So Gavin Newsom and Merrick Garland advanced. We also saw Elvis Chan of the FBI San Francisco field office advanced over Margaret R. Cook for the Massachusetts Department of Health. Now, you may remember that Margaret Cook was behind that spyware that got illicitly downloaded onto every Android phone in the state of Massachusetts without people's knowledge and without their permission.
Yeah, even if you flew into Logan Airport and you weren't a Massachusetts resident, it would get downloaded on your phone as you flew through. It's horrible.
So we thought, I thought I would see a better contest here between Chan and Cook, but Elvis Chan actually, of all of the Flagrant Four, he had the highest margin of victory. 90% of the votes came in for Elvis Chan.
So you're telling me Elvis has not left the bracket?
He has not left the bracket. He may well be the king of the bracket. And that tees up a really great face-off between Gavin Newsom, who has vastly greater name recognition, and Elvis Chan, who has done things I think that people are much, much angrier about, specifically a lot of that censorship on Twitter and other social media companies, a lot of it having to do with the election. And honestly, Mark, what we've seen is that some of the things, the very true things that were censored by Chan and his colleagues, are things that if people had known about them, the polling shows they would have changed their votes. Now, you
want to see election manipulation. I mean, Elvis Chan is election manipulation personified in some respects, it looks like.
Oh, absolutely. Absolutely. And not to take anything away from Gavin Newsom's attempt to silence doctors and prevent them from talking honestly with their patients about things that the government narrative doesn't want them to talk about. So it's not like Gavin doesn't deserve to win, but I'm interested to see Newsom versus Chan. It's a great face-off here in the Flagrant Four.
And Chan is fresh off a victory against another state bureaucrat, so maybe give the federal edge there if there aren't enough Californians to hate Newsom to overcome the.
Well, I got to tell you, we're talking about two Californians here, right?
Oh, is that right? Okay.
Because Elvis Chan is in the San Francisco field office, so really, this whole side of the bracket is all about how problematic the state of California is, and how those folks are inside a bubble.
It should really be on the west side of the bracket instead of the east side of the bracket, though, shouldn't it?
That's a mistake on my part. I'll have to fix that next year. Now, Mark, the thing I think we really want to talk about is, and every year the tournament has a game like this, has a matchup where someone was down by 2 points with under 10 seconds left, and they take a long shot from nearly half court as the seconds drain away. And what I'm describing is exactly what happened with the face-off between Richard Cordray, the COO, Chief Operating Officer of the Federal Student Aid at the Department of Education, and Douglas L. Parker, the Assistant Secretary of Labor who runs OSHA, the Occupational Safety and Health Administration. These two,
who already surprisingly knocked off Lena Khan in the last round.
Douglas Parker,
FTC chairman,
an unexpected juggernaut, knocked off Lena Khan and was absolutely marching to victory here in the elitist 8 against Richard Cordray, who we know is behind that terrible student loan
debt cancellation
fiasco. Well,
which the Supreme Court's about ready to, I think, do away with. But anyway,
thanks to lawsuits brought by patriotic organizations like NCLA,
some of which you may have heard of.
Yes. But Cordray took a 3-point shot at the last minute, drained it, and Douglas Parker does not advance. Instead, it's Richard Cordray. I had to reprint out the bracket before I came on the show because it happened literally just minutes before I came on.
So in Kansas, we call it Mario's Miracle from 2008 when he hit the long 3-pointer to tie it and send the game to overtime. What is there a name for Richard Cordray's sort of come from behind win here?
Yeah. I think it's Cordray's colossal come from behind, right? So, and look, that tees up Richard Cordray, who is a bureaucrat's bureaucrat, John. I mean, I think you and I have talked before about this guy keeps popping up in different agencies. If there's some bureaucratic shenanigans going on, chances are Richard Cordray is your boy, right?
Right. He's the Wilsonian's Wilsonian.
I would say he keeps turning up like a bad penny, except last time he turned up, it was like a bad $500 billion. So,
yeah, that's right. That's right. The and he has got a very large Herculean task ahead of him, and that is to knock off Merrick Garland, who from the beginning has been the front runner. I mean, he has destroyed a series. First it was Stephen Dettelbach at the ATF. And then that wasn't really surprising, since you can tag some of the bump stock stuff to Merrick Garland as well.
Well, and he's Dettelbach's boss, right?
Exactly.
So, and who do you hold responsible, the underling or the supervisor?
And then he faced off against Connecticut Attorney General William Tong, and that was a lopsided match. And then he, just as we talked about, destroyed Rob Flaherty. I'd like to see, Richard Cordray had a tough time getting past Douglas L. Parker. Can he bring the game against Merrick Garland? I don't know. It's gonna be interesting.
It's gonna be tough.
Yeah,
I'm just glad to see Richard Cordray make the Flagrant Four myself, because I think of you say he's the bureaucrat's bureaucrat, the Wilsonian's Wilsonian. I mean, this guy believes in the power of unelected officials to run your life for you. It's a core belief for him. And you saw it when he was the head of the Consumer Financial Protection Bureau, where he was the second most powerful person in the United States government, according to the DC Circuit, because this was before, I think that's probably still true, actually, that the head of the CFPB is the second most powerful person in the government. But this was even before some of the reforms. And now he ran for governor of Ohio. He lost. He's been stuck back in the Department of Education to cook up not just this $500 billion debt, forgiveness scheme, but there's also 2 or 3 other programs that the Department of Education has been pumping out to try to forgive debt in other ways that are unlawful as well. He's just a disaster. That's my pitch.
Yes. A disaster, and specifically a menace to anyone who believes that legislation belongs in Congress and not in the executive branch. I mean, he is a bureaucrat with dreams of being a legislator, it seems to me. Although you're right, he stays in the executive because I think he understands that under today with the constitutional lawlessness run amok, he understands that he doesn't have to be a legislator. He doesn't actually get votes to pass laws. He can just become a powerful executive bureaucrat.
So remind folks, Clegg, how they can vote in this competition if they want to, because we're down to the Flagrant Four. So we will be announcing the winner of this contest. Remind us.
Yes, on June the 1st.
June the 1st.
The winner is going to be announced, and that means there's just really, I mean, we are down to the last 30 days.
Yeah,
basically.
How many voting days left till Christmas? So that's going to be my question.
Exactly. We got a little over a month. The Flagrant Four is going to be live, so you can either several ways to vote. You can go on to Twitter. We do polls. Vote on those polls. Check us out. New Civil Liberties Alliance.
At NCLA Legal on Twitter.
That's right. And then we also have a webpage which lays all of this stuff out. And it is nclalegal.org/KG3 or King George III. If you just search NCLA KG3 on Google, you'll go right to it.
Yeah, or if you just go to our webpage, again, nclalegal.org, and you just scroll down a little bit, I think it's the second item on that homepage there. So you can find it that way too, very easily.
Well,
that's how I found it recently.
I'm actually very proud of our communications folks, because if you search for King George III or KG3, and it's the first response on Google.
Yeah, so, just above the Hamilton musical.
Yeah, we've locked in the King George III. Which, right. Even better than Hamilton. But Mark, I am still working on getting. Is it Jonathan Goff? Is that the guy who played King George III in the original Hamilton? Still trying to work on getting him to come and do an event for us, but
that would be fantastic.
That's a 6-figure get. So I don't know if that's a good use of our a good use of our donors.
No, you just have to wait till he's a little further off his peak. We'll get him. If we can't get him for the 10th, we'll get him for the 20th.
Yeah. Well, I think he's going to be like Carol Channing. She could be Dolly no matter how old she was. I think that's going to be the same thing. I don't think it's going away.
He's found the role of a lifetime.
Yeah.
So we have again the final four. On one side of the bracket, it's Gavin Newsom against Elvis Chan. The other side of the bracket, it's Richard Cordray against Merrick Garland. Do you want to make a prediction, or I guess we're almost out of time here. So any final thoughts?
Well, my final thoughts are just that at CPAC, the straw poll actually had Gavin Newsom and Merrick Garland facing off. Will that hold true? I think that's what I'm wondering. It certainly looks that way.
It does look that way. I'm secretly harboring hope that Richard Cordray will pull out victory. We'll see. I think this is the one election he deserves to win.